I am going to talk to you about industry engagement, as Juan just said. Disclosures. Very pertinent to this talk, gang. Good. So I'm going to talk to you about working with industry today. It is a very nice thing to start your own company, and can be quite taxing, can be quite rewarding. It's also quite difficult. And as you start along your path to innovation, an easier way to move along that path is to partner with someone who's already established. And that would, for example, be industry. So I'm going to talk to you about how to do that ethically and how to do that legally. This is kind of an overview of what I've done over the years. I have started and sold several companies. I have also done a lot with industry. And so you can do both. I talked about this morning, and I think it's a fundamental truth. When we're innovating, we're trying to solve clinical problems. We're trying to do things better than we may have done them in the past. And ultimately, it's about improving patient care, right? Hopefully, not only improving patient care, but improving overall value such that they're getting better outcomes at an incremental cost that makes sense to the entire system. That being said, when you're doing these things, you do need to know some of the rules out there. And if you don't know the rules, number one, you can be taken advantage of, and number two, you can get in big trouble. So you'd like not to end up in either of those situations. So I'm also going to talk about intellectual property, and then I'll talk about some of the legal guidelines that you've got to follow. So one of the things I did in anticipation for giving a talk like this was to talk with a fellow who was the head of technology development for a very large device company. He's since retired from that, to look at it from his perspective and ask, what are companies looking for in a partnership, in an ethical and compliant partnership with surgeons? Because it turns out, engineers alone and marketing people alone, can't pull off this task of innovation. I don't think they do it as well as they can if an insightful surgeon or surgeons get involved in the process. And so they know that too, and that's why this interplay can be so productive. So just some practical advice from this fellow, and you can read through the slide. I'll just highlight a few things. If you're going to go pitch an idea at a company, right, understand how their businesses work. Implants, for example, are being commoditized. And there are some unique implants that can be successfully brought to market, but in some ways, a screw is a screw is a screw, right? There are other areas that are hotter, that companies are much more interested in, be it artificial intelligence or machine learning or augmented reality, et cetera. And the point is that companies will pay a little bit more attention to these ideas, perhaps, than they might to older school commoditized fields. It is key, though, that as you bring an idea to a company, that you have your idea protected. We'll talk about how to do that relatively inexpensively and preliminarily, but make sure you've protected yourself before you go talk about your idea. And you can have people execute a non-disclosure agreement. It's a lot better to have already gotten some form of protection of your idea from my point of view. And that's what this fellow who's done this for a couple of decades recommends. You want to build relationships. People like to work with people they know and trust. And you can build these relationships by engaging with people, getting out and teaching at conferences or teaching for companies, getting to know people and letting them get to know you, where you present yourself obviously as a knowledgeable, reliable, affable sort of person. And it sounds simple, but it works. And those relationships can absolutely pay dividends. You can start with a consulting relationship. When you do this, you pay close attention to that consulting contract. The other advice from this fellow was to have realistic expectations. If you're successful with this, you will make some money. It's like going into neurosurgery, though, right? You're probably not going to get rich doing it. You're going to be comfortable. And you know, I tell people, do this if you've got a passion for it. I love it. As I said this morning, I think it's a way to have an influence beyond your two hands, because if you develop something that your peers embrace and that helps patients, your influence extends well beyond what you can do on a day-to-day basis. Surgery, after all, is piecework, right? It's like we're sewing, and we can only make so many articles of clothing. If you develop the process that allows others to make those pieces of clothing more efficiently or better in other fashion, now you've had this outsized influence, if you will. That being said, most people who do this are not going to make a fortune. If you look, and you can go onto the government website, you know, it's interesting to me that we as physicians have to, all this data is tracked on us. It doesn't happen in any other industry, quite honestly. But I put one company as an example here just to show you that if you look at this and say, well, I'm going to do this just to make a lot of money. Well, not so much. In the year 2019, the company paid $16 million in royalties, a lot of royalties, right? But 10+ million of those went to only 15 surgeons, and they had over 200 surgeons working with them. And so you do the math, you're gonna make some money if you do this successfully. It's just, you know, unless your idea really catches on and really it changes the field or grasps the attention of your peers, it's probably not going to be as lucrative as you might have hoped, and that's okay. You know, you're doing this again to try to make the field better. Be careful with contracts. Always have an attorney review your contract. Always, 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 and be careful of what people are offering you. Some smaller companies are, I'm just going to be blunt, they want your surgical business, right? They want you to put their implants in. And they will come up with means of inducing you to do so. Make sure that the consulting you're doing is really consulting, right? Make sure that there is actual value to the service that you're providing. We'll talk about that in a bit of detail. And then the opposite can be true with the larger companies. The larger companies are managing the bottom line. They're trying to please Wall Street. You know, they're on their earnings report. They better show growth that beats the street consensus. You know, yada yada yada. They're cutting costs, and so you want to make sure that you're being compliant, but you also want to make sure that you're being fairly compensated for your time. So I'll get into some practical matters, IP and legal guidelines. You all solve problems every day. Do it all the time. Innovation is problem solving with some rules, with some guidelines. I like to think about things that haven't changed in a long time, because almost always there's going to be a better way to do those things. As in terms of being creative, it's interesting. There are a few relatively simple strategies to enhance your creativity. This is based on work in neuropsychology. So it turns out that when we're groggy, we're more creative. If you look at puzzles that measure creativity, your ability to be creative for solutions, people do better on them when they're groggier. daydreaming may be an offshoot of that, but there's been research that shows that when you daydream, you're more creative. I'll in what's called twilight sleep. I'll sometimes have my best ideas at about 3 in the morning. My wife will say, "Oh, your toes wiggled last night. You must have thought of something." And I'll tell you, write those ideas down. Later in the day, you say, "Now, what was I thinking this morning at 3 a.m.?" But research confirms that you're more creative at these times. Thinking like a child turns out to enhance creativity. And humor, interestingly, tends to enhance creativity. So if you're going to want to protect your ideas, you're going to file for a patent. Patents are enshrined in the U.S. Constitution. So our forefathers envisioned that patent rights were going to be very, very important to the health of the nation, and they are, right? So, but what is a patent? A patent is actually not a grant of right to do something. It's actually a right to exclude others from doing so. So it's protecting your turf for a while. And the typical patent that you're going to be pursuing as a spine surgeon is a utility patent. And utility patents last for 20 years from the earliest filing date. Now, that's important because when you file, your patent may not issue for 5 or 6 years, right? The clock is ticking. That's coming off the time when you have exclusive rights to that patent. As an interesting aside, copyrights go for 70 years plus the life of the author. Seems unfair. Honestly, it is. So if Taylor Swift writes a song, and I invent a new widget, she has rights to her song well beyond the time that I have rights to my widget. Interesting story why that is. We can talk afterwards. It actually has to do with Mickey Mouse. It's an interesting story as to why copyrights last so long. So types of patents, pay attention to the top two, provisional patents and utility patents. Utility patent is the whole shebang, where you lay out your idea, you include your drawings, and you include the most important part of this patent, what are called the claims. A provisional patent application basically lasts a year from when you file it, and we'll talk about what it actually covers. You can patent anything new and useful. You can't patent abstract ideas, laws of nature, and concepts that can't be applied, can't be practically or brought to practice. You can patent a way of doing things. You can patent a machine or an apparatus that lets you do things, so method patents and device patents. You can patent how you put things together. And really, really importantly, you can patent an improvement of any of those things. That's key, because sometimes you'll see a new device and say, why didn't I think of that? And you want to look at that closely and look at their IP, because they may have not thought of all the ways one might practice that invention. And if you come up with an improved way to do that, your idea can still be patentable. Basic patentees. Your idea has to be novel. Basically, it's new over the prior art. The prior art is what's out there published in the patent literature, and you can search the database on Google Patents or uspto.gov. But the prior art also includes what's in the literature, what you've said at a meeting, and so your idea has to be new over all of that. And be careful about running out and blabbing about your new idea before you've gotten some kind of protection of that idea. It's got to be non-obvious. This is a subtle but important distinction. I can't claim an improvement that would be obvious to the average person, right? There has to be what they call an inventive step in order to qualify for patent. And then again, you have to be able to reduce it to practice. You have to actually be able to use the thing. So when you're going to patent something, you're going to disclose your invention. You want to record that. Then there's going to be a prior art search. You can do part of this yourself on the websites I talked about. You're going to want to, in my experience, employ a patent attorney at this point, but they're going to do a much better prior art search. And you don't want to waste time and effort if your idea is already out there somewhere in the prior art. Then you've got to prepare the application. You can see the aspects of that. I'm not going to go into them in detail. Keep notes when you come up with ideas. Ideally, have someone who's not involved and who's not a relative initial that for you to kind of document when you came up with your advice. Very, very, very important. Who's an inventor? Well, technically, an inventor, you say, well, I must have come up with the whole invention. Not true. We talked about in the patent application, there will be at the end what are called the claims. I claim a new device that revolutionizes spine surgery by allowing things to fuse in 2 seconds and the patient to walk out the door in 3 minutes. And then that'd be claim 1. Claim 2, wherein the device in claim 1 consists of yada, yada, yada. If you contribute to any of the claims in an invention, you are, by law, an inventor in that. Keep an eye on that. Sometimes people will deny you patent rights when you really did contribute to that invention. It works the other way, too. People will say, well, that was my idea, too. Yeah, but you didn't contribute to a claim. I'm gonna quickly, I'm running out of time, talk about a couple other things. A provisional patent application. You can get it, the form on the USPTO.gov site, $150, cheap. It documents your idea. There's no examination, but you now have a whole year. You can use the term patent pending, and you have a whole year to file your utility patent. Absolutely learn about that. Okay, anti-kickback statute. Be careful about this. It prohibits the knowing and willful solicitation, receipt, offer, or payment of any remuneration, anything. They send you on a trip. They pay for your wife to fly. They take you out to dinner. Make sure that if you're getting anything, there has been some sort of service that's at fair market value to justify that. These are the elements of the AKS. Bottom line is easy to fall into the trap. Then there's the False Claims Act, which individuals or entities that knowingly file fraudulent or false claims. This is where whistleblowers come into play. And be careful, because these are the people who are looking for fraud. And trust me, it includes your partners, it includes employees, former employees, and your competitors, right? They can all whistleblow you for fraud. Here are the keys when you're going to get paid by a company. It's got to be a bona fide business need. You have to have been selected on a legitimate basis, unrelated to referrals. In other words, it can't be, oh, he's our biggest implant user. That won't fly. You have to be paid at fair market value, and then you must have provided something of value. You want to document all of this. This will protect you if someone claims that, oh no, you just violated the anti-kickback statute. You can say, au contraire, A, B, C, D. I did not, and here's why. Watch out for indirect forms of payment. Watch out for consulting and advisory payments that really don't have anything to do with a legitimate need for consulting. They say, oh, you're evaluating our device while you put it in. Oh, really? Try to defend that. And bad actions have consequences. Here's a spine surgeon who had to pay the Department of Justice $1.75 million for doing what was deemed to be sham consulting. Here's another spine surgeon. There seems like there's 1 or 2 of these on Becker's every week. This was for accepting $300,000 in kickbacks. So bottom line, it's entrepreneurship, innovation, great things to do. They help the field, they help patient care get better. You guys have the opportunity to do this because you've got a unique knowledge set and skill set that other folks don't have. Learn to protect your ideas, and working with industry in a lawful way is completely legitimate. Thank you very much.